Good afternoon and welcome to the SRA webinar on outcomes-focused regulation. My name is Tracy Calvert and I am one of the presenters today. I'm a lawyer and I've worked for the SRA and previously the Law Society for 13 years. I'm currently a policy executive in the standards team and I've recently been involved in drafting the new handbook in readiness for outcomes-focused regulation and for alternative business structures. I'm joined today by my colleague Jenny Eden.
Hello, I'm Jenny Eden. I'm also a policy executive in the standards unit and I've also worked for the SRA and the Law Society for a number of years and have been involved in drafting the handbook and in particular the Code of Conduct, which we're going to look at in more detail today.
Thank you, Jenny. I'd just like to give you an overview of what we'd like to talk about today. We'd like to start with a presentation which will provide you with a brief description of outcomes-focused regulation, the handbook and the new Code of Conduct. We would then like to talk in more detail about particular aspects of the code, during which we will be carrying out a poll to canvass your views on certain issues.
As you may know, we're currently consulting on the second draft of the new handbook and we see this webinar very much as a two-way process. An opportunity for us to give you important information about changes that are taking place in the regulatory regime and also an opportunity for you to give us your feedback on our proposals.
Thank you. As well as the polls, there'll also be an opportunity for you to phone in with your questions or send in your questions by email, and we will do our best to answer all of these at the end of the presentation. Don't worry if we don't have time for your question though, because all questions and answers will be posted on our website.
So what do we mean when we talk about outcomes-focused regulation, or OFR? It's basically a whole new regulatory approach which moves away from compliance with detailed and prescriptive rules and focuses on acting in a principled manner to achieve the right outcomes for your clients. It's intended to allow firms flexibility in the way that they provide services to their clients, taking into account the needs of their clients and the nature of their firm. And it also allows us as regulators to focus on real risk and the underlying purpose of the regulatory requirements. Tracy, would you like to say something about the new handbook?
Thank you, Jenny. What we are planning to do is to introduce an online handbook which will for the first time bring together all our regulatory requirements in one place. So for example, you will find requirements relating to the training regulations, authorisation, the new Code of Conduct, more specialised rules dealing with things like property selling and accounts and indemnity, as well as the disciplinary and compliance rules. We intend that this handbook is going to apply to everyone we regulate, so not only solicitors and traditional law firms, but also the new alternative business structures.
There are 10 principles which underpin the new regulatory regime. So they underpin everything that's set out in the handbook, not just the Code of Conduct, but all of the other regulatory requirements. And they stand separately, they're not part of the code, they're actually a separate part of the handbook, whereas at the moment they're set out in Practice Rule 1. There are 10 principles, as I said, and 6 of them will already be familiar to you. They reflect the basic principles that are set out in Rule 1, and they deal with things like upholding the rule of law, acting with integrity, and acting in your client's best interests. There are also 4 new principles which are set out here, which require you to comply with your legal and regulatory obligations and to deal with your regulators and ombudsman in an open, timely and cooperative manner, to run your business or carry out your role in the business effectively and in accordance with proper governance and sound financial and risk management principles. There's also a principle dealing with equality and diversity, which requires you to run your business in a way that encourages equality of opportunity and respect for diversity. And finally, there's a new principle requiring you to protect client money and assets. And as we've said, these principles underpin everything that's set out in the handbook, but the code in particular sets these in context. for example, in the context of client care, conflict, confidentiality.
Okay, so let's have a closer look at the code itself. You'll be able to find the code on the website as it's one of our consultation documents. It's the most obviously different looking document in the handbook, and whereas the current Code of Conduct, the 2007 code, which you'll be familiar with, contains prescriptive, detailed rules with even more detailed guidance, the new code is comprised of outcomes and indicative behaviours. We believe that this code will allow you to achieve the right outcomes for your clients, taking into account the way your firm works and its client base. So in drafting this code, we've recognised that not all firms operate in the same way. Jenny, perhaps you can run through some of the features of the new code.
Thank you. As we've said, the code is made up basically of outcomes and indicative behaviours. Now, the outcomes are mandatory and set out the standards of behaviour that we expect from all firms. They are mandatory, so you will need to comply with all of them where they're relevant to your firm. And there may, of course, be some that aren't relevant, such as the outcomes relating to referral arrangements, if you don't have those kinds of arrangements. So you'll need to exercise judgment in deciding which of the outcomes apply to your firm. And we'll look at some examples of the outcomes shortly.
Okay, so Jenny has said outcomes are mandatory, but you will exercise judgment as to whether or not a particular outcome is relevant to your firm. Moving now to indicative behaviours, these supplement the outcomes. They specify examples of behaviour which may establish compliance with or contravention of the outcomes. What they are not, though, is an exhaustive list, and that's because we recognise that there may be other ways of achieving the outcomes, and this very much depends on the needs of your clients and the size and the nature of your firm. If you choose another method, we may ask you to demonstrate how you have nevertheless achieved the outcome.
And here, just by way of example, we've shown you a couple of examples of indicative behaviours relating to client care. The first is simply that you treat your clients fairly, and the second is that clients are in a position to make informed decisions about the services they need, how their matter will be handled, and the options available to them. And you'll see how this contrasts with the current practice rule 2, which is very specific and prescriptive about the information that you need to give to your clients. If we move on to look at the indicative behaviours, you'll see that this does list some of the sort of information that you're currently required to give to your clients, but it's more flexible in that these are not mandatory, but you might want to consider these as the type of information you would normally give to clients. But that will depend very much on your client and the type of work that you're doing for them. So the information that you give to a sophisticated business client won't necessarily be the same as you'd give to an individual who's never instructed a solicitor before.
Thank you. Jenny has said you all know your clients best, so you all know how best to meet the outcomes in these scenarios. Moving now to guidance, unlike the current code, the new code will not contain detailed guidance apart from the indicative behaviours, which are, as I said, a type of guidance as they're not mandatory. There will, however, be information on our website to help you with compliance. We've chosen this method of publishing guidance because we feel it means we can respond to issues as they arise, rather than having guidance which may become quickly out of date or take on a status of its own. With this in mind, we've tried to make the outcomes and indicative behaviours as clear and self-explanatory as possible. So let's have a look at some specific areas of the code, and let's start with conflicts of interest. Conflicts of interest is going to be dealt with in Chapter 3 of the draft Code of Conduct, and the first 3 outcomes are shown on this slide. The outcomes don't actually reflect any significant change in policy. Outcome 1, for example, requires you to have effective systems and controls in place to enable you to identify and assess potential conflicts of interest. This reflects the current requirements in Rule 5 of the 2007 Code. What is new is that we are not being prescriptive about what type of system or what type of controls you have in place. In an outcomes-fashioned manner, you will know how best to implement a system which meets the outcomes. And that system will then, of course, be dependent on your type of firm and your type of clients. Outcomes 2 and 3 deal with the types of conflict that can arise. Outcome 2 deals with what we are now describing as an own interest conflict, which is a conflict between you and your client. And the outcome is that you never act where there is an own interest conflict. Outcome 3 deals with a situation where there will be a conflict between two current clients, and we're calling that a client conflict in the new code. What we are saying is that you should not act in a client conflict except in exceptional circumstances, which I'll describe in detail in further slides. Moving on to the indicative behaviours which support these outcomes. The indicative behaviours help you assess whether there is a conflict or significant risk of conflict and whether you should refuse instructions. So where you are dealing with a conflict between two clients, you'll want to consider whether their interests are different, for example, and whether your ability to give independent advice to the clients is fettered. The indicators like this may suggest to you that you cannot act in the best interests of the two clients. Ultimately, though, it's going to be a matter for your own judgment, and you'll need to bear in mind that you will need to act in the best interests of each client to comply with each of the underlying principle. And the second of the indicative behaviours deals with own interest conflicts. That is to say, the conflict between you and your client. And we give examples of situations where we feel you may need to exercise judgment, including such things as a financial interest or a personal relationship, which prevents you from acting in the best interest of each client. Moving now to the exceptions to the general rule that you can't act for two clients where there is a conflict between them. These exceptions aren't new, and they reflect what's in the current code. The first exception is in outcome 4, and this deals with a situation where the clients have a substantially common interest, which means that there must be a clear common purpose and a strong consensus on how that is to be achieved. So, for example, you may find you're acting for several individuals setting up a company, and any area of conflict is substantially less important to the clients than their common purpose in the establishment of that company, and may relate, for example, to slightly different views on how the common purpose is to be achieved. The second exception is in outcome 5, and that relates to where two or more clients are competing for the same objective, and this should only be relied upon with extreme caution. Examples include acting on insolvencies, so that a firm could act for more than one